What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody, and happy Valentine's Day. Thank you for spending at least part of it with me, and maybe tonight as well, as we are going to continue breaking down the Alec Murdaugh trial. But in this video, I wanted to give a little Lori Vallow, Chad Daybell update, as that trial is less than 2 months away, and a lot is happening. We did a couple videos on Lori Vallow's motion to dismiss this case for lack of a speedy trial. Technically, she is correct. The judge has reportedly made his decision. We have a part of that order. We don't have the whole thing. If you have the whole thing and want to send it to me, go ahead. I think I know pretty much what his reasoning is, or what his what he held in the highest esteem or put the most weight towards based on these couple pages of his order, and why he ultimately denied her request to dismiss this case for lack of a speedy trial. We will talk about that. And there was a hearing last week where they dealt with a bunch of different issues, as they always do, coming down toward the trial. These pre-trial hearings is where we get a lot of this last stuff hammered out, figured out what's going to come into this case, what's not going to come into this case, how's it going to get argued. And there are still a couple things up in the air, which we'll talk about those as well. So if you're interested in this Vallow Daybell case, hit that like button and subscribe to our page, because we are going to do our best to continue following this case, even though there are no cameras in the courtroom. We are not going to stream audio only of this trial and break it down word for word, but we will try to keep up with the trial and give updates as the trial goes along. It's supposed to be weeks and weeks and weeks. So we'll do some kind of recap and update if you all are interested. And you can let me know if you're interested by subscribing and liking the video and getting in the comments and letting me know that you want me to continue following this case. Okay, so first things first. They have extended the discovery deadline. And what does that mean? That means anything new that's going to come into trial, there has to be a deadline and a cutoff date. So you can't do any more depositions, produce any more evidence, produce any more documents that you plan on using at trial. And you would think, okay, maybe this will help the defense because the state has to stop at some point. Well, up to the date of that discovery deadline, the state can dump documents on you, and they very often do. And prior, Chad Daybell's lawyer argued that since December 25th, there have been 4 different basically chunks of discovery that they've given them. The latest was a week or two ago where 1,100 pages of documents were produced, and it is literally impossible for him to get through these by the end of February, which was the original discovery deadline. He said he's not even going to be able to prepare for them by the time the trial date is set, which I think is about 6 or 7 weeks from now. The state proposes a compromise. Well, why don't we move it to mid-March instead of the end of February? And that is where Judge Boyce, I believe, has settled, extending that discovery deadline to allow this discovery to go on for just a couple more weeks. But I think Chad Daybell, through his lawyer, I think it's John Pryor now. His first name is slipping my mind. But I think they have a very good argument that that is totally unfair, and they are not going to be able to adequately prepare for this case, which, again, adds to the intrigue, in my opinion, that it is fundamentally unfair to force Chad Daybell to stay connected to Lori Vallow when she has demanded speedy trial and he has waived, and he is telling the court he cannot get ready in time. Now, at some point, you do have to force the case to get to trial. You can't let a defendant delay forever and ever, and avoiding their day in court, which I don't think that's what Pryor or Daybell is trying to do here. I don't think he wants to just sit in jail forever because he is incarcerated at this point. But at some point, it is okay for the court to force them to go to trial. I don't think we are there yet. More on that later. They also talked about jury questionnaires and how they are going to give the jurors questionnaires ahead of time, some of the content that's going to be in there, and the judge will allow certain circumstances for them to go one-on-one and question jurors individually. I like that. I think that's fair, especially in such a high-profile case where the venue has already been changed, because we realize that jury pools can be affected by the reporting and by the national news and the documentaries and docuseries and things on this case. So I think it's appropriate that they allow and that the judge allows individual questioning. There was some back and forth, it seems, that they said, well, we'll start in groups, and if we need to do individualized, then we will. But it seems like they are going to be able to dig in on jury selection, which is really important in trying to get a fair and unbiased jury pool. Number 3, there was a lot of talk about some sensitive matters, such as questions about punishment, meaning the death penalty, mental health issues, and domestic violence or religion. A lot of discussion about religion. One of the defense attorneys said religion is going to come out a lot at this trial, and a lot of these allegations are about the LDS religion. We believe it's information we need. Now, as you know, religion and people's religions is a protected class. You cannot strike jurors for their religion. However, I do think in these circumstances, knowledge around that certain religion or knowing people involved or have been in and then gotten out or having certain feelings towards that religion could be important in this case. And I think it is fair game and should be fair game. The state objects, as they should, and, argue that that's inappropriate. That's like saying somebody's race or national origin is a reason that we should be able to keep them off this jury, or their political affiliation, which a lot of times lawyers try to figure out anyways. But the state argued against it, and it seems like the judge is going to allow at least some questions about the LDS religion. And there will be something about that for if the lawyers feel like they need to dig in or it makes them a biased juror in this case, then they may be allowed to strike for that reason. It seems like it's going to be open and honest and not one of these where, I have a minority client and the other side is striking every minority juror and I'm doing a Batson challenge, which is like, give me a race neutral reason why you're striking that juror. And they make up some race neutral reason that's totally bogus. But they just don't want that person on because of their race, but they can just give some race neutral reason. And usually that's enough. It seems like this is going to be more upfront and honest and saying, listen, we think their feelings about that religion could affect this case. Not what their religion is, but their feelings about it. I think there is a potential chance you could differentiate from that, but it is a very touchy situation that you do not want to cross over into striking people because of their protected class. So I do think that's going to be interesting in how they handle that. The prosecutors also said because we changed venue, that shouldn't be that big of a deal. And lastly, before we get to the denial of the motion to dismiss, it seems like the judge, based on Pryor and Daybell's asking for a reconsideration on their motion to sever, has not made his final decision. And I think all this talk about speedy trial may make Judge Boyce reconsider. He has pushed that out to February 23rd. They have another hearing, and the judge is going to make his decision on the motion to sever or the reconsideration of that at that time. Now, I would still lean the judge is going to stick to what he's been doing and not allow and deny that motion to sever and keep these cases together and force them to go to trial together. But as I look at it, and I've kind of said from the jump, I realize it's going to be a waste of time and resources, and we're going to have to do this big, long, expensive trial twice, wasting taxpaying dollars of that state. But we want to protect the rights of criminal defendants in this case, of the accused in this case who's presumed innocent. And at this point, forcing them to go together seems fundamentally unfair to me, especially with this speedy trial issue and these discovery issues that they're having. Now, why did Judge Boyce deny Lori Vallow's motion to dismiss for lack of speedy trial when technically it is outside the time period allotted for her speedy trial? We broke down those motions and responses at length. So we've only seen bits and pieces of this order from Judge Boyce denying Lori Vallow's motion to dismiss for a lack of speedy trial. And the main reason it basically boils down to, which is something we discussed when we were looking at the motions going back and forth, will they dismiss it? Will they not dismiss it? Because technically it is outside the timeline, is that Judge Boyce said Lori Vallow, in agreement with Chad Daybell, wanted to change the venue of where this trial was going to take place. And that change in venue created a delay. And that delay is not attributable to the state. He also differentiates that delay and change of venue is not the same as court congestion, which has been held multiple times to not be an appropriate reason to violate somebody's speedy trial rights. But this is the change in venue creating the delay, not attributable to the state, which basically means attributable to the defendant, which is a reason why you can allow it to go outside that speedy trial time period. Additionally, he weighed the factors of how difficult this is for Lori Vallow. Yes, she is still in prison this entire time. She probably has anxiety about it. She probably has issues about it. Of course, anybody would. But It is not a huge delay. It is not a delay that's going to impair or prejudice the defense. Frankly, we have one defendant arguing he needs more time to prepare. So I think that having Daybell make those arguments that we discussed earlier in the video is actually helpful to the court, saying this isn't impairing Lori Vallow's defense. If anything, it's helping her. And they've actually had less time to prepare for trial because she had competency issues for a portion of the time that Chad Daybell has not, and has been able to help and assist his lawyer in prepping his defense. So at the end of the day, I think it really comes down to the fact that she agreed to change venue. It created a slight delay, and the delay is just that slight and not enough to dismiss a case of this magnitude. Now, is it going to be an appellate issue? You better believe it. It will absolutely be an appellate issue, in my opinion, in this case, because anytime you have a trial go outside the speedy trial period and the court agrees, she absolutely demanded speedy trial and did not waive her right to speedy trial. There's no argument about that in the court's mind. The court believes she did demand a speedy trial, but the court believes everything has been done diligently by the state and the court doing everything they can to bring this case to trial. And therefore, he is not going to dismiss and throw out this indictment for Lori Vallow for multiple murders. Let me know if you think that's fair in the comments. Let me know what you think about that in the comments. And again, like this video if you are interested in me continuing to follow the Lori Vallow, Chad Daybell saga, because it has been a wild ride. Cameras are gone, but we will still be here. If you all are interested, let me know what you think. And until tonight, I'll see you then.